So hello everyone, myself Advocate Gautam Harshwal working, welcome to Dialezee. Today in this video I am going to discuss the recent update on the Gyanvapi Kashi Vishwanath case, which is a very controversial case also. This case is kind of Ram Mandir case which was being in which the judgment was being given in 2019, but this case is a fresh case. This is the case which was being filed by the petitioner, senior advocate Vishnu Jain. So what happened in this case, I am going to discuss in this video. So let's start our discussion without any further delay. So in this case, basically the Muslim parties, the defendants in this case, basically moved before Supreme Court of India for allowing wuju during the Ramzan. What that means, let's find out in this video. So in the batch of pleas concerning the Gyanvapi Kashi Vishwanath dispute, Muslim parties have moved the Supreme Court seeking permission to carry out the practice of wuju or ablution inside the mosque premises during the month of Ramadan. We all know the month of Ramadan or Ramadan is a very sacred month for all the Muslims around the world. If we talk about Muslim religion, so that's why they moved before the Supreme Court to basically asking for permission of wuju, right? So the issue was being mentioned by senior advocate Huzaifa Ahmadi on Thursday before a bench of Chief Justice of India D.Y. Chandrachud, who agreed to list the case on April of 14. The Chandrachud said that please file an interlocutory application in this regard, and we will take this up on April of 14. Said basically the bench has said this in this case. And the wuju area of the Gyanvapi mosque is the center of dispute between Hindus and Muslims, since the Hindu parties claim that a shivling has been found in their dispute. The Gyanvapi dispute arose when Hindu devotees approached a civil court claiming the right to worship inside the premises of the Gyanvapi mosque on the ground that it was a Hindu temple and still houses Hindu deities also. And the civil in this case, basically, as I said before in this case, as I already discussed, that it's a basically controversial case because the parties are altogether different. The one side is Hindu and the other side is Muslim. So further in this case, the civil court had ordered a survey of the mosque by an advocate commissioner. The advocate commissioner then conducted the videographic survey and submitted a report before the civil to the civil court. Based on the survey report, the Hindu parties claimed that an object discovered at the site is a shivling. The Muslim parties, however, disputed the same and said that it is only a water fountain. Right, so we all know that this was all the reason of controversy of which was being which was in the center of this case. And meanwhile, the suit before the civil court was transferred to the district judge by the Supreme Court on May of 20th. In view of the sensitivity of the issue involved, the district court on September 12th held that the suit was not barred under the Places of Worship or Special Provisions Act 1991. On November 17, a Varanasi court found the suit filed by the Hindu party seeking possessory rights over the Gyanvapi mosque maintainable. The decision was appealed before the High Court by the Committee of Management of Anjuman Intejamiya Masjid, which reserved its verdict in December last year, right? So further in this case, in October, a Varanasi court rejected a plea filed by the Hindu parties seeking directions to the Archaeological Survey of India, which is ASI, to conduct a scientific investigation to ascertain whether the object found during the survey of Gyanvapi mosque premises is a shivling or a fountain. This promoted an appeal before the Allahabad High Court. Right, so the High Court also asked the Director General of ASI to submit his opinion on whether carbon dating ground penetrating radar, which is GPR, excavation and other methods to determine the age of the disputed object at Gyanvapi mosque would damage the object. In cases most recent development, Allahabad High Court on Wednesday basically pulled up the DG of the ASI for failing to file her response as directed by the High Court. So, in this case, the Supreme Court will hear this matter on the 12th of April. I will definitely discuss what happened in this case of 21st of April. The Hindu parties plead to consolidate all suits concerning the dispute which are pending before the Honorable Varanasi Court. So that's all about our discussion. I hope you understood what I have discussed in this case. So before you go, I want you to subscribe this channel and share this video with your close ones, your family members. We always come with some business content on this channel and some legal content also. If you have any suggestion regarding that, let me know in the comment section. Till then, bye bye. Take care.